Bharadwaj, on behalf of EBC, feel deeply honored to welcome you all on this momentous occasion where we gather to release Obscenity, Prevention, Law and Practice by Mr. Saurabh Bindal. Published by EBC, Mr. Bindal's book delves into the intricate realm of obscenity, exploring its legal dimensions and offering valuable insights into its prevention and practice within our society. Today, we have an exceptional lineup of guests who will share their perspective. We hope that this will be an evening of inspiration, curiosity, and engagement. So, without further ado, let's welcome the dignitaries on the dais. It is my great pleasure to welcome Justice Rajiv Shakdher, a true embodiment of legal brilliance and excellence. With a distinguished career spanning over 3 decades, Justice Shakdher brings with him a wealth of experience and expertise in civil. While we are all aware of his excellence in the legal field, not many know that Justice Shakdher is also a chartered accountant. To put it in the Gen Z terminology, Justice Shakdher's perseverance and multifaceted achievements are truly #goals for aspiring legal professionals. Sir, we are honored to have you as our chief guest today. I would like to request Mr. Sumain Malik, Director EBC, to felicitate Justice Shakdher. Please allow me to welcome the illustrious Justice Prathiba M. Singh, whose remarkable career spans over 3 decades. Before being elevated to the bench, she was a leading intellectual property lawyer in India and played a crucial role in shaping India's first national IPR policy as a member of IPR think tank. Not only this, the Prathiba M. Singh Scholarship for LLM students, established at the University of Cambridge in 2013, is a testament to Justice Singh's dedication to fostering the next generation's legal minds. With unwavering commitment to excellence and a passion for law, Justice Singh serves as an inspiration to aspiring legal professionals. We are honored to have you here with us, ma'am. I would like to request Mr. Raghunandan Malik, Director EBC, to felicitate Justice Singh. Please join me in welcoming Mr. Sidharth Luthra, Senior Advocate at the Supreme Court of India, and a true inspiration to legal professionals everywhere. With a career spanning over 3 decades, Mr. Luthra was designated as a Senior Advocate in the year 2007 and served as Additional Solicitor General from 2012 to 2014. His unwavering commitment to seeking justice and upholding the law was most evident in his role as the Special Public Prosecutor for the state of NCT of Delhi in the Nirbhaya case. Mr. Luthra is also an esteemed member of the Supreme Court Cases Editorial Board. As one of India's most accomplished legal professionals, Mr. Luthra is an inspiration to all who aspire to make a difference. We feel privileged to have your presence amongst us, sir. I would like to request Ms. Sabah Anis to felicitate Mr. Luthra. A lawyer's role is not just to win cases, but to ensure that justice is served for all. Our next guest, Ms. Nitya Ramakrishnan, Senior Advocate in the Supreme Court of India, exemplifies the true essence of legal profession. Known for her expertise in human rights and criminal trials, Ms. Ramakrishnan has served as a defense counsel in notable cases such as the Harin Pandya murder case and the 1993 Bombay bomb blast case. She has also made a significant contribution in media and censorship-related cases, showcasing her commitment to upholding freedom of expression. Through her unwavering dedication to justice and her impactful work in the legal field, Ms. Ramakrishnan is a shining example for aspiring lawyers and a true advocate for the rights of individuals. We are truly honored to have you here with us, ma'am. I would like to request Ms. Kriti Kumar to felicitate Ms. Ramakrishnan. Please join me in welcoming our next guest, Ms. Puja Talwar, a media powerhouse with nearly 3 decades of experience in the entertainment media industry. She has been associated with renowned media outlets such as TV18, NDTV, The Hindu, to name a few. Ms. Talwar's remarkable contributions to the media industry have garnered her numerous accolades, including the prestigious Indian Tally Award for her groundbreaking documentary on Kiranjit Ahluwalia. In addition to her impressive achievements, Ms. Talwar has spoken on women in South Asian films at the SARC conference and has moderated events such as the International Film Festival of India and IFA Homecoming. Ms. Talwar is truly a force to be reckoned with. We are delighted to have you here with us. I would like to request Ms. Apurva Goyal to felicitate Ms. Talwar. Please welcome our esteemed moderator for today's event, Ms. Anusha Soni. Ms. Soni is a senior journalist with CNN News 18, where she writes and reports on critical legal issues. Her expertise in the field has made her a sought-after commentator, and she also anchors primetime shows for the channel. Prior to this, Ms. Soni has worked with the other renowned media houses such as India Today and Business Standard. A little birdie has also told us that when Ms. Soni is not covering legal news, she likes to fiddle with Kathak and Sangeet. We are delighted to have you here with us today. I would like to request Ms. Riddhi Khurana to felicitate Ms. Soni. It is with great honor that I now introduce the man of the moment, the brilliant Mr. Saurabh Bindal, partner at Fox Mandal. With a unique blend of legal expertise and an engineering background, Mr. Bindal is not only a highly accomplished lawyer, but also an accomplished writer, having authored and co-authored several books and papers with national and international publications. The book that we have gathered today to witness the release of is his 8th book and 5th with EBC. This is a testament to the perfect partnership between Mr. Bindal and EBC, showcasing their mutual dedication to producing high-quality legal literature. I would like to request Ms. Diksha Dabas to felicitate Mr. Bindal. Established in the 1940s, EBC has been at the forefront of providing quality legal resources to professionals and students alike. As director of EBC and associate editor of SCC, Mr. Sumit Malik has played an integral role in taking EBC's legacy to new heights. Beyond his contributions to the publishing world, Mr. Malik also serves as the head of the finance chair at Entrepreneurs Organization, Uttar Pradesh, highlighting his diverse abilities and dedication to excellence. I would like to request Ms. Arshia Jain to felicitate Mr. Malik. Director EBC to deliver his welcome address.
Mr. Justice Rajiv Shakdher, Mrs. Justice Prathiba M. Singh, Mr. Sidharth Luthra, and Ms. Nitya Ramakrishnan, senior advocates, Ms. Puja Talwar, Ms. Anusha Soni, our author, Mr. Saurabh Bindal, senior advocates, judges, students, and gentle people. It is my privilege and pleasure to welcome all of you to this event where we will be celebrating the release of the book on the law relating to obscenity by Saurabh and the panel discussion that is to follow. I'm also happy to welcome Saurabh's family who is here with us this evening. I am grateful to our chief guest and our guests of honor for taking the time out to participate in this event. EBC's association with Saurabh is spread over many books. EBC published his co-authored book on intellectual property in 2015, a new edition of which is in press. He has revised the latest edition of Dr. Avtar Singh's book on arbitration and co-authored a book on the Arbitration Act with R.V. Prabhat. This will be his 5th book by EBC and his 8th book otherwise. In this new world of technology and artificial intelligence, ChatGPT, which allows for instant self-publishing, publishing on blogs, etc., the question is, how do we at EBC see ourselves? What is the role of a publisher? In today's context, I can say that we see ourselves as the trustee of the legacy of authors. We have, over the years, continued to preserve the legacy of authors, names that are synonymous with the study, teaching, and practice of law. Whether it was Professor V.N. Shukla, Professor Kelkar, Dr. Avtar Singh, Professor Ahmed Siddiqui, Sri V.D. Mahajan, Sri V.G. Ramachandran, Professor T.K. Tope, Professor B.M. Gandhi, and others. And their books are revised at regular intervals. Using SEC Online, a user can, within seconds, bring out all the material related to obscenity. So when Saurabh and I spoke about publishing this book, the emphasis was not on the exhaustiveness of the material on obscenity, but a detailed analysis of that material. There was many a back and forth between him and us before the manuscript finally transformed into a book that is before you. A book, as I see it, is a custodian of thoughts and ideas. Whereas judges, when deciding cases, are bound to decide the list before them on a given set of facts and apply the law to those facts, authors, when writing books, do not face such limitations. A good author will explain the law to their audience, but a great author will also show the light forward by placing their thoughts and ideas in the book of what they consider the law ought to be. Saurabh has done that in his book, and we will be witness to a very interesting panel discussion on obscenity in the digital world, Digital and Globalised World, Freedom and Fetters, later on the program. To sort of set the tone, I want to quote from what Mr. Robertson, barrister, has to say on the subject of and the book, and he says, and I quote, "During the craze for obscenity trials at the Old Bailey in the 1990s, juries were told that obscenity was like an elephant, impossible to define, but you knew it when you see it. Juries increasingly found the elephant invisible, and these prosecutions have ended, other than for child pornography, and criminal law is no longer used to censor bad taste and rudery. It is the same in Europe and America. But in India, the old English common law lives on, now frequently in statutory form, requiring judgments on material which tends to deprave or corrupt or is indecent because of its sexual explicitness. In this book, Saurabh provides an authoritative and illuminating guide to the obscenity law of the nation that gives to the world the Kama Sutra. It is a fascinating subject as judges wrestle with legal tests that are invariably vague and subjective. Its analysis provides a degree of coherence to the subject and will be essential reading for all those involved in the drawing of lines that delineate areas where speech is not free. As we at EBC enter the 80th year since our incorporation, what we have learned to understand what the legal profession requires and what our role can be in fulfilling that requirement. We believe that our role is to bridge the gap between legal information and knowledge and those that consume legal information and knowledge. As a third generation member of this publishing house, I have been blessed to have been shown the way by my elders. My granduncle and grandfather had very humble beginnings, delivering books and bicycles to lawyers, including the great Mr. Ambedkar, when they started off as booksellers in 1942. But even then the mission was clear: provide a service which will assist the practitioner in her work. The mission continues with the same spirit when EBC started publishing books for lawyers and students in 1947. The books we produce must necessarily be of very high quality and assist the user in their quest for knowledge. To be effective in our role, it is important that the materials or contents that we produce is authentic, accurate, and reliable. Also, we've continued to innovate over the years to keep ourselves relevant. In 1969, when Mr. Suren Malik graduated from the Delhi University, having studied by the newly introduced case method, he realized that there was a need of faster reporting of Supreme Court judgments. Thus came about the innovation of Supreme Court cases. All of you are aware that there can be no second edition of a law report, and it must be got right the first time. Prompt, accurate, and complete has been our philosophy, which has been adhered to since then, and we understand and recognize our responsibility that honorable judges and the bar rely on Supreme Court cases. He has now taken up the onerous task of reporting judgments of the Supreme Court since 1950 to 1968, a period not covered in SEC earlier. But in the first 10 volumes published, we have discovered and reported many important judgments of the court hereto never reported before. With the High Court cases, HCC, our newly launched venture, we begin the journey to report judgments of the High Courts of India with the same alacrity and comprehensiveness as we report the Supreme Court. Interestingly, we noticed that when reading the judgments carefully, that words like fool's cap become full's cap and conjointly become co-jointly. We are also fortunate to have, as part of EBC, a family, EBC family, a dedicated team of legal editors, software engineers, DTP staff, proofreaders, sales and marketing staff, and managers who are as much, if not sometimes more, invested in ensuring that what is produced from the house of BBC is of high quality, authentic, accurate, and reliable. It has been a wonderful experience working with you, Saurabh, on this book, and I'm sure that we will continue he will continue writing and we will continue publishing. Thank you.
Thank you, Sumit sir. I would now like to request the chief guest for today, Justice Shakdher, to address the audience.
Thank you so much. Good evening to everyone. And first and foremost, I must thank Mr. Sumit Malik and Bhumika Indulia and her team for enabling this congregation. So, had it not been for you, maybe all of us wouldn't have been here. More importantly, for discussing a topic which is so very relevant in today's time. Second, and not because of the number I've given it to it, is I must congratulate Saurabh for doing an outstanding work in putting this book together. We are living in a WhatsApp age where people don't have time to read books. What Saurabh has done is produced a slim version, let's say, of law, which captures almost every facet. The book has about 13 chapters. It navigates through 14 statutes. It gives you what was the law prior to the amendment taking, in 1969 there was an amendment. Lawyers would know that in section 292 of the IBC, and how the law thereafter progressed post the amendment. For anyone who's interested in the topic, this is a good book. It's not boring, it's not heavy, it's written in a readable style. So therefore I would commend everyone, lawyers, those journalists and other people who are generally interested in how law progresses in this area. So my 2 pennies on the subject, because I've been given only 5 minutes for opening remarks. I'm sure as the discussion takes place on the panel, we'll have more to hear. In fact, I would have wanted a more interactive session where people would have aired their views, because I detest actually this oration business where I stand on the podium and I give you my gyan and others have to listen. It almost seems that I am addressing a captive audience who have nowhere else to go. But since I am here, let me just tell you what my view is on this topic with which courts are confronted day in and day out. Generally, for those who are not initiated in law, they should know that we have a fundamental right to free speech. It is, as the Indian Supreme Court has said, the most precious of the fundamental rights that has been given to us. So Article 19(1)A gives us the right of free speech and expression, but that right is not absolute. It has some they have restrictions. Although we got inspired by the US Constitution, which is equivalent to Article 19(1)A, they have what is known as the First Amendment. Theirs is a more open-ended provision. There is no provision for reasonable restrictions. And this aspect actually came to fore when they were dealing with I don't know whether this generation reads those kind of books, what is known as the Lady Chatelier's Lover. And this was actually the author writing about the pain, trauma, loneliness that the woman went through. And she had a physical relationship with someone outside the marriage. Now, why I was telling you about the US Supreme Court and the Indian Supreme Court is the same book was dealt with several courts in different jurisdictions. It was dealt, actually in the US, they were dealing with a movie made on Lady Chatelier's book, and they were called upon to rule whether the movie should be banned or not. India, we dealt with the book. Canada dealt with the book. UK also dealt with the book. Now, in all the 3 jurisdictions apart from India, there was no ban. India, the judge and of course the Constitution bench, when they were looking at and they were examining the law, the criminal provision, that is 292 of the IPC, they felt it did not add anything to scholarship. I mean, to the society, to scholarship, and therefore the restriction in our free speech, which the state can put on the grounds of decency and morality, kicked in. And therefore, the judge concerned, who was writing for the court, said, no way, this book is not good enough. And the person who actually, got it in the neck was someone who had actually kept the book in his bookstore. So that's the extent of the sufferance that someone can face if he has a book which he doesn't even know will be tomorrow declared, or any article that it will be, categorized as something which is obscene. Therefore, what the courts are called upon to do is, despite there being parameters, is to discuss those parameters in the context of a particular set of facts. So before the 69 amendment, we had what is known as the Hicklin test. Hicklin was a very interesting gentleman, and he did something I thought which he did in 19th century would have appealed to most people. All that he did was, and this is where religion sometimes even makes judges fuzzy. And I'll tell you how. Because Hicklin did something which any sensible man would do. He exposed the Roman Catholic Church. The priests there were, during confession, asking all sorts of questions. He published a pamphlet saying, this is not on, this is a confession, you can't, ask those questions, etc. But he got it in his neck. He got convicted. But interestingly, even then, at the first appellate stage, the concerned judge acquitted him. It was when it came to the so-called law lord, he had a very peculiar name called Cockburn, who said, no, you have to apply a test which is, does it corrupt or deprave minds which are open to immoral offenses. Now, this is as vague as it gets, and this test was what was applied by the Indian court in what is known famously as the Ranjit Udeshi case. So therefore, we stuck with this test till there was an amendment. And what was the Hicklin test was, you could pick up any passage in the book or in an article, and if that article would, according to the judge, deprave or corrupt, you were convicted. The courts evolved their own procedure. There was an amendment which said, no, you have to look at the whole matter. But the vestiges of the Hicklin test were still embedded in the statute, which was done away with when the Supreme Court wrote in 2014 the Avik Sarkar judgment, which was very interesting. I mean, this generation would perhaps identify more with those facts where Boris Becker and his girlfriend posed in the nude. The court actually gave them a free pass. I was just wondering, if you take it from 2014 to today, whether, what would happen, apart from the huge noise that we would hear on how could you do that. In fact, a Kerala case even did better. This was a woman, which was of 2023. There was a woman, she uploaded a video, and she wanted to question the default sexualization of a woman's body as against a man. The point that she was trying to sort of put across was, when a man is in public bare-chested, no one questions, but if a woman is in public bare-chested, everyone questions, and this is default sexualization. She was taken to court. Mercifully, the judge had a different approach. He said, no, it doesn't come within the periphery of the penal law. So what we are dealing with, and this is what legal scholars are struggling with, is it dependent on the social mores of the judge? Because the test that we have developed is, does it accord or align with the current community standards? That is good, but it's still vague. Why? Because according to me, when I look at the matter, if I'm a person with a liberal disposition, and I go back to my youth, that's something that judges sometimes forget. What was I like when I was 18 and 20? And what am I now when I'm sitting and judging at 18 and 20 year at 60, and I sometimes become, this very moralistic person. So the point is, it is still vague. So legal scholars say that should it be so vague, or should you just stick to what the Constitution provides? Now, some legal scholars say all that you need to look at is it a sexual act accompanied with violence, or is it a sexual, or the other alternative, is it the sexual act which is not accompanied by violence but which dehumanizes or degrades a person? Say, suppose you are depicting a woman, and if it is not in that rarefied zone, then you should be in the clear. Now, this is a narrower restriction as against what is presently prevailing in courts, which is, current contemporary standards. Now, that is as vague as it sometimes gets. It's a difficult thing, but I'm sure while we are discussing and at the panel, you'll have a chance to have a go at it. So wait for the discussion if you're still interested. Thank you very much, and good luck to Saurabh.
So you were mentioning about audience being captive. I think that was quite a captivating address. Thank you, sir. Ladies and gentlemen, it is now time for the momentous occasion that we have been waiting for. I would like to request Justice Shakdher to please release Obscenity, Prevention, Law and Practice by Mr. Saurabh Bindal. I would also like to request all the esteemed guests on the dais to open the packages placed in front of them and hold the book in their hands. Thank you, everyone. That was truly a remarkable moment to witness. It is now time for the thought-provoking panel discussion on the topic Obscenity in a Digital and Globalized World, Freedoms and Fetters. I would like to invite Ms. Anusha Soni to take over the baton.
Good evening, ladies and gentlemen. Thank you so much for being a part of this very wonderful evening. And as the learned judge pointed out, what can be a more topical issue than obscenity to discuss in today's age and time? In the age of social media, where everybody thinks they know what's right and wrong, what's acceptable and what's not acceptable, Saurabh's book is a fantastic account of what law thinks. It's sharp, precise, and anybody who's a serious student who wants to learn what the law really is about, this is the book to read. Before we dive into the discussion, which we're all very keenly looking forward to, Saurabh, your thoughts. What prompted you to write on the topic of obscenity? 8th book, and a very brief one, I would argue, because on obscenity, everybody has a lot to say, and they believe they are the authority. But you've exercised a lot of caution when you've written this book.
Writing is a habit for me, so I keep on writing a lot of stuff. But this subject came, very close to me, because these days we have to discuss about what is obscene and what is not obscene. This is an age where a lot of things are there on social media. You have OTT platforms, you have, a lot of web series, you have a lot of series which have, objectionable scenes, and there's a need to discuss about whether there's a law to protect that, whether there's a law looking at that. So when it came to me that I should, figure out whether there is some law on this. So when I was doing my research, I found out that there's no book on this very subject. So, that provoked me to, do a deep dive in this subject and, find out what the law on the subject is. And the story is very interesting. I came out with this idea that I'll write a book, and I shared that with Mr. Malik. So Mr. Malik said that you should do it. I made the first manuscript that went to Mr. Surendra Malik. And I was in a function, book launch function. Mr. Malik said that you should meet Mr. Surendra Malik. He's looking for you. So I went to meet him. He pulled my ears and he said, "Is this the work you are going to give to the society? You have written, this is your 8th book, so you better do justice to it." And after that, it has been 5 manuscripts. I have been churning out, things. And eventually he agreed. He said, now we can go ahead with the publication. So I hope that this book becomes quite useful for everyone. And I have restrained myself, from giving my views in this book, because I just wanted to say that this is the law. And it is for everyone, on this panel to discuss what is their idea of obscenity.
Isn't it the most difficult thing these days to not to give your views, but to just state what the law is? I'd dive straight into the discussion. Justice Prathiba Singh, ma'am, I'll begin with you. And this is an aspect of obscenity that has always intrigued me as a student of law. That is it about just the male gaze of how they see women's body? Justice Shakdher also spoke about it very briefly. What aspects of obscenity are related to the setup of patriarchy, and to what extent has law evolved on the subject?
Thank you so much, and thank you for the question, and thank you EBC for having me here. My first experience of EBC was when I was opposing them in the biggest copyright decision in the Supreme Court. So I've known Sumit and the whole Malik family since then, and therefore I wanted to make a special mention of it. Coming back to patriarchy and how obscenity should be viewed, I was just having a discussion with Sidharth also as to why should obscenity be viewed only in respect of a woman or a female. I think obscenity can be from various points of view and from different dimensions. Let me give you a few examples. For example, I remember from the perspective of intellectual property itself, if you look at trademarks, any obscene trademark can't be registered, and on that the US Supreme Court has now spoken, and that as per the US Constitution now is unconstitutional provision. We have an identical provision in law in the FUCT judgment, which Saurabh has referred to in his book. But that's from the perspective of what's a mark that can be registered. Let me tell you from the other perspective. There can be, obscene use of a trademark. One of the few cases that I dealt with is a case involving the trademark Kurkure. Right? We all know Kurkure, and what can be bad about Kurkure, right? But suddenly there was a case where in Telugu, someone came out with a porn movie called Kurkure. So it was dilution of the brand by a porn movie, and therefore the aspect of obscenity came in infringement of a trademark. So the perspective is completely different. So we could immediately file a suit, got an injunction, and did all that. Let's look at patent law, for example. I'm sure all of you are aware of, I can't remember the name of the drug. The TRIPS agreement says anything which is contrary to ordre public, not public order, but ordre public, can be excluded from patenting. Ordre public is a limited exception compared to public order. It's much more diluted. That came in because of the European community. Now, would we say that a chemical, for example, which can be used in a pesticide, which can also be used in weapons, can you stop it from being patented? Obscenity has very, very big dimensions. It need not be from the exposure of a female body or a woman, or it can have very multiple and multidimensional views. And therefore, I think that writing about obscenity, and I must congratulate the author for having a complete chapter on intellectual property and obscenity. That would be my opening remark.
Thank you. Thank you for that opinion. Ma'am, Nityaji, I want to come to you and I want to understand from you. There's an interesting concept in the book that sort of discusses, and it's about what's obscene at a public place. there's a line that the law draws between a public and a private place, what's acceptable and what's not acceptable, and how can any question today be devoid of the social media space and the world that we are living in. But how do you see the law and how has it evolved? Do you think the entire concept of public versus the private space, with so much of social media glare and the access to each other private lives, those lines have blurred? Has law taken really, cognizance of that?
Saurabh's own discussion shows that something which is viewed as a private space because people have to pay and belong to a certain class to access it in one judgment. The same nature of place was was treated as a public space in another judgment. So the context determines many of these things. The question is important, what do you call a place when it comes to social media? Because it's no longer a physical space. The difficulty for regulation always comes when you have technology which is several steps ahead of regulation. And the proliferation of information, images, discussion, and the reach is so immense that you're both driven to wanting to regulate it and realizing that the regulation will always be inadequate. Which brings us back to the question that both the notion, one thing only is static, that is the elusiveness of the term obscenity and of space. Given that it's such an elusive concept, I think the question that arises is what I think Mr. Malik also referred to it, how much of it should we try and regulate through criminal law and by bans? Other than, of course, when child pornography, there are specific things, sometimes obscene acts in public or public accessible places. I think that was the distinction in Saurabh's two judgments. One said that it's whoever can access it, but it is accessible, it is prone to access, and therefore we will treat it as a public space. And judicial views are also prone to change, not necessarily in time, but at the same time, different judges view things differently. In fact, just an aside, I really wish that Saurabh had dealt with the various Manto trials. Because you see, in that you see, the judge who held him guilty met him at a coffee shop and said that he really admired the work greatly, but he felt as a judge he had to think of society, whereas as an individual he understood the literary value of it. And the book was eventually dedicated by Manto to that judge. So the notions of judges change. So question is whether this form of expression, purely as expression, should be amenable to regulation through criminal law or through a prior ban, subject to important exceptions. And here I say, I'm not saying it's not a problem, but two things we must keep in mind. Where expression is under control, and I'm coming back to your private and public places, where definitions are so hard to define, the question is whether expression per se should be subject to state control through criminal law, because no matter which the government, there is a tendency to abuse expression. I'm not making a universal statement that any law which is prone to abuse must go, because there are some things which you cannot avoid making offenses, notwithstanding that they can be abused. But there is no way, but they're more clearly defined. Abuse is an incident, but where the very proneness of a notion in criminal law and a ban is abuse, I think it's time to reconsider how we regulate it. So your private-public question, I say that these are mutable notions. Mutable because of the subjectivity of the judges, mutable because of the concept, mutable because of technological reach, and the very fact that I'm not able to answer you definitely suggests how elusive the topic is.
Justice Shakdher, the elusive concept that Nitya ji spoke about, also a mutable concept, something which is dynamically changing and evolving. You very candidly mentioned that it's subjective. Sometimes the judges forget how they behaved when they were younger. But whenever a question of obscenity, to decide what's obscene or not, comes before a judge, is there a standard of objectivity that can be applied? Are those standards changing very dynamically? How do judges really decide upon these questions in a very fast changing world where regulations are not able to catch up?
Yeah, so as I said, what is prevailing in India are the test of contemporary community standards. The difficulty with applying this test is what is the contemporary community standard. And as I said, the social mores of the judge play a very important part, as would be evident for the examples that I gave you. In Kingsley, the US Supreme Court said, it's par for the course, doesn't matter, it should go through. Of course, they don't have the reasonable restriction clause in their First Amendment, but nevertheless, they let it go. UK let it go. Canada let it go. Now, we had a judge who was, my colleagues here would agree, was a out-and-out Englishman. If you read that book, Ranjit Udeshi, when he dealt with Lady Chatterley's love, he writes beautifully. And he also says that, when I say that it doesn't, it breaches that, or it comes within that restriction of it being indecent and immoral, he says, I'm not saying that Michelangelo's work should be covered with breaches. So, there is, if you look at it, yeah, there are nude paintings of saints and other people. So, coming back to the difficulty that a judge has every day is, how do I apply the test, the facts of this case? Which is why I said in the opening, the area of discretion for the judge should be narrower so that there is more objectivity and less subjectivity. So I agree with those legal scholars who say, if it is about sex with violence, surely say no. If it's about child pornography, surely say no. And if it is, say, sex which without violence, but it dehumanizes and degrades, say no. Rest, I'm getting into a space where, one who creates that work would know better. And the example that Nitya gave about Mantu, you must read. It's an interesting dialogue that the judge had with the complainant, where he said, what is so obscene? He said, well, Mantu in his work speaks about a woman's bosom, and the author got up and said, how else do I describe it? He uses a very colorful expression. He says, how else do I describe it? Now, so, authors and artists are actually pretty flummoxed whether they should or should not write. Perumal Murugan, which was a author, about that. He wrote about a particular practice and there was hue and cry. Fortunately, you were before a judge who was a liberal and he let it go. M.F. Hussein's work, it may be distasteful for some of us, but that is not obscene. Vulgar is not always obscene, is the test for these kind of cases.
I think that's wonderfully put, that everything that's vulgar is not necessarily obscene. Mr. Sidharth Luthra, the presence of vagueness and the absence of a certain degree of finality to what exactly is obscene, has it made the penal provisions designed for blatant abuse? As ma'am pointed out that, any law can be abused, but is it more prone to abuse compared than the others?
So the problem with some aspects of our criminal law especially are that wherever there is vagueness, and as Justice Shakdher and the others have said, we apply the community standards test. That test will actually vary from jurisdiction to jurisdiction. I was glancing through the book and I must, one of the cases which you mentioned is Ekta Kapoor, which was one of the OTT serials called XXX Uncensored. And I'll tell you my own experience. For some reason, I couldn't open the video on my device. It was COVID time, I was locked up. It was a case going on in Madhya Pradesh High Court. And we've been arguing that it was adult content. We lost there. And I'll tell you why I'm coming to this. The day I opened it and I said, oh help, with this content, this is not going to fly. And I'm putting it very bluntly in the heartland. I realized at that moment we're going to have trouble in this case. There's no way we're going to succeed in apportionment, and we did not. We succeeded in some of the peripheral provisions, but there was no way. We took the matter to Supreme Court, and the first question that was put to us is, your argument is adult content, isn't it? And the matter was admitted. So the variation as a result of the community standards test varies from, these days it's fashionable to say, Bharat and India. I must say this, so you will find that this test varies, and therefore once you have a, no. You've then not seen my article in the Express on this. I'm very clear in my mind. The difficulty that is faced is, let's leave the courts for a moment. Let's come down to brass tacks. When material which is alleged to be indecent comes to the notice of that head constable or the sub-inspector, how is he going to perceive it? How is she going to perceive it? Is the judge sitting in Delhi or in Bombay versus a judge sitting in, let's say, in Joshimath, going to perceive it similarly on contemporary standards? Because that's where the law is set in motion. That's where liberty is interfered with. So my biggest concern about such laws is the very ambiguity. And as Justice Shakdher said, all of these laws need to have the contours defined so that there is clarity for those who apply the laws and implement it. It was all very well to have a test which we applied way back. And I must commend to all of you that when you look at any provision in the Indian Penal Code, because the test of the Indian Penal Code on obscenity has really been carried into all other statutes. Look at the IT Act everywhere, it's really the same test. Please look at the debates on the Law Commission that brought out the Indian Penal Code. It makes fascinating reading. It's a clear case in a lot of areas of imposition of their understanding and Victorian morality on a race which at times was called beastly, uncivilized, beastly people with a beastly religion and beastly habits. Now, they're really looking down at us and bringing on some provisions. Some provisions are brilliant, I must say this. The Indian Penal Code has stood the test of time. So when you look at that perception, and if anybody wants, I have a copy of that Law Commission report, which I got, yeah, sure. Somebody gifted it to me many years ago, and I maintain it. And I read it whenever I have to read one of the provisions, because the contextual analysis is 160 years ago. And you brought it down and continue to apply it. Can it apply today when our social and sexual mores and our understanding of what is appropriate or not appropriate will vary? So these are serious concerns in the implementation of the law, and especially when it interferes with human liberty, they are very, very serious.
While you were elaborating, I was thinking to myself, contemporary standards of who? The vast diversity and scape of this country makes one wonders that what is normal for one may not be normal for the other. And I believe this diversity / subjectivity sometimes becomes open to abuse, like we have seen. Puja, you deal with social media a lot. You have seen the kind of content which is there on social media, on the OTT platforms, the kind of comments that are generated. How difficult or easy it is for you to say, well, this is something I would want to be legally prosecuted and this is something I want to ignore?
You know, the former a lot more these days. And because I agree with what Sir said when I started off as a 22-year-old journalist. My first report was on fire and the riots that happened at Regal, because it dealt with homosexuality and the two women. And now me as a 50-year-old, deals with things very differently. But as you said, on social media, it's an untamable beast. And there are many times that it's happened with me when I wanted to report women, in this case, 4 women who had become wild, abusive. And I did approach a childhood friend of mine who's now an advocate in Supreme Court. He says these are internet wars. There's nothing you can do about it. You can die down. Do not react. I first reacted. I called them out like, being women, how are you dissing women? And they carried on. He says these are nameless, faceless people. Most of them under fake identities. You will lose this. After that, a superstar died, and we know how the journalists were across, male and female, were trolled. And maximum comments came from women again, against women. Hope you die, men send lewd pictures. You could not do anything about it because, again, Instagram and Facebook are American companies, and what this person has posted does not adhere to our legal whatever. So most of the times they just end up blocking these people, and yes, your mental health goes for a toss, but there's nothing you can do about it, you know. And also, if you go on Instagram and on Facebook and on Twitter, the kind of content that is available, and you do know they're young kids. I mean, though Instagram and Twitter says not above 14, 15 or something, but they're young kids spewing venom, sending suggestive videos, photographs. I mean, yesterday, I'll just tell you, I reported on a Korean actor who's 24. Her fan club is liking, and so we just sat down to see what the comment is. It was a porn site. And you actually wonder a lot of times, where is this coming from? Because and also with influencers, because today your social currency determines how popular you are. And there are a lot of people who, at age 18, I would have said, oh, she's so cool. But now I'm like, why are you doing this? And then the same person stands up and says, my modesty has been violated by so and so. But why are you putting yourself out there in that situation? I know, as ma'am also said, that a woman's body should not be objectified and seen as erotica vis-a-vis a man's. But now I really don't know, because on social media most of the time I actually feel that one needs to be protected, because you could be the victim or you could be victimized too.
I understand what you're saying, and social media is not a double-edged sword, it's a multi-edged sword. You just don't know which way it's really going to play. But Mr. Luthra, you had a comment to make.
So I'll tell you in one word, obscenity sells. Let's understand that. Some of the work I have been doing for the last couple of decades is to review books, to review TV programs, to determine whether they are liable to be prosecuted or not for the kind of content. So about a decade ago, I remember when OTT was just starting out, I got and I'm not going to name the client, I got a request to review a channel, and I looked at their content and I told the legal manager, I said, there is no way you're going to escape the rigors of the law. You are going to be prosecuted so many times. You'll need a mammoth team of lawyers. To which his answer was, and I said, take this back. I gave a written opinion on this. He went back and he came back. He said, Sidharth, thanks for your opinion and we appreciate your concern, but let me tell you this. Our business rivals are doing it. We don't have an option. So the first thing we must understand is it's commerce driven. The second matter which concerns me a lot is that the English language OTT channels are sophisticated. The real beasts that are out there are the Hindi language channels, the regional language ones, and when you pick up a phone anywhere, you're getting free subscription to this.
Yes.
So let's be very clear about it. Go to I travel a lot within rural India and different parts. Go to any rural India, every child has a smartphone. It may be a basic smartphone, but people who can afford the basic material, I have the smartphone, and therefore they have an access and they have membership. So you have a situation where, with the nebulous nature of the law, people are pushing the limits to the extreme, and therefore there is a reaction which is going to come, a social reaction. It doesn't help matters that your laws as they stand are nebulous. And the other problem which I face, and I must say this, and I've spoken about this many times over, I think it's a fundamental time when the legislature, when parliament starts relooking at how we make laws. Everything is now governed by parliament with some delegation. The only exception has been the Epidemic Diseases Act, the Disaster Management Act. Otherwise, everything is centralized with parliament or the state legislature. Technology will not wait. Technology far outstrips the reach of law until we, and perhaps it's a whole way of relooking at making the law, till we start relooking at how the laws are to be framed, especially in these areas where clarity is given to the man at the bottom who has to actually determine whether a crime is to be prosecuted, and the individual who needs to know whether his or her liberty is going to be affected, we're going to have problems. And that will really have to change with the way we draft and frame legislation with more delegation.
And can I add to what Sir said? Because I am in agreement with this, because recently I spoke to a filmmaker who was known to, it was Anurag Kashyap who made movies like Devdi and LSD and everything. No, not LSD, Devdi. And he said the problem now is, if you see the OTT platforms, a lot of them basically have content and stories that are set in India, regional, in the hinterland. But there is so much of sex and violence added, he says, because that titillates and gets them the eyeballs. Sure. Though they make everyone else very uncomfortable. And as Mr. Luthra also said, kids these days have access to that phone. Everyone has a phone. You cannot control the content they are watching. These days, movies, I would say, are still way better in terms of, because they want to promote family viewing. But there are a lot of times an 18-plus movie has young kids in the theater, but nobody's checking that out. Because I remember, I grew up in the 70s. We could not watch an adults-only film, but a 7-year-old now has seen an adults-only film because the parent says, oh, there's nobody at home to look after the kid. But what it does to an impressionable mind.
I'd just summarize the concerns that have been voiced in terms of how can one regulate the content which is there on social media, on OTT platforms, in languages other than English, which are far more prevalent in our country, say Hindi or regional languages. The audience is wider and perhaps not so educationally equipped to deal with the content which is coming to them. And going to the learned judges for their views, Justice Shakdher, law, has it become completely redundant to tame the beast that, say, Puja spoke of? And is there a need for a legislative intervention or a rethinking in this country as to how obscenity needs to be tamed legally or regulated without really getting into the domain of censorship, because there's a thin line?
Yeah, so we come back to the same question. When you're dealing with obscenity, how do you define obscenity? Because it comes up before the judge. And all of us make the same point that, for regulation you need precision. And if you don't have precision in law, it becomes very difficult to regulate. That's one. The second is you're dealing with technology, which is that social media platforms have what is known as safe harbor protection. So under Section 79 of the Information Technology Act, they are not the content providers. Content is provided to someone else. So they say, I am only giving you a platform. Now that platform can be used for what I call, or what legal scholars call, is high value speech and low value speech. High value speech will be a critical comment about the general affairs of the powers that be, politicians, their conduct, etc. You criticize them. That's par for the cause. Low value speech is something like, porn, obscene material. Best example is bully sites, correct? Now that needs to be tamped down. How do you do it? We have guidelines. The Government of India has come out with guidelines. That was in 2011. In fact, in 2021, they've come out with guidelines. So the only way you can do it, insofar as a social media platform is concerned, is for them to disclose to the world at large what is the algorithm that they use for sieving this kind of content. Because they have, in one sense, a genuine technological difficulty. There are hundreds and millions of posts put. Now the AI or the application that is put there is not always able to sieve it. That's one reason. The other is what Sidharth also said, or one of the panelists said, is these are big tech companies. The more this kind of content is there, there's more viewership, there's more money in terms of ad revenue, etc., etc. So the only way that the various state authorities sort of try to grapple with this is to put them into some kind of a ring fence by saying, okay, you will disclose your policy, you will disclose your user agreement, and when you're told to take off something from the platform, you will abide. And of course, I think that they should disclose what is the algorithm. Is the algorithm good enough to exclude this content? That's technology for you, and unless you can deal with it, you'll have very little chance.
Sure.
Confession. I represent a lot of these companies. But having said that, I must tell you, I was part of the process that led to at least some of the guidelines that came in relation to child porn and RGR, rape and gang rape material. That process went out before a bench of the Supreme Court, which goes to show that a lot of this is not government driven, which should really be government driven. It ends up being court driven, and court driven reform is very useful, but sometimes it will have its limitations in terms of broad basing the kind of consultation that's needed. Having said that, and to add to what Justice Shakdher said, there is now technology to make out nude material, pornographic material. But I'll give you a small example. A man in swimming trunks versus a man wearing trousers, or a woman in a bikini versus a nude woman, depending, or partly clothed woman. The question is really, you are going to do a data analysis of how much skin is showing up. So the algorithms run. It becomes very difficult sometimes for the algorithms to make a distinction, exactly what you were saying, between the nude photograph and the partly clothed photograph, because it's just analyzing, it's all, and that's what's happening. The difficulty with most of the tech companies is nobody's going to share their algorithms easily, because according to them, that's their proprietary information. More Justice Prathiba Singh's domain than mine, whatever little I understand of it. Nobody's willing to come out, and the problem is, of course, there's a mechanism where, at least in the US, they have to report any such material which comes to their knowledge to an organization called NCMEC, NCMEC. NCMEC is then tied up with the Government of India, and that information is now shared. And the reason for these 2021 guidelines was, earlier, if you had a problem with any of the tech companies, who did you trace? You had to send a communication through the MLAT process, which would take months. Now with the people who are placed within India, at least they can reach out to the officers concerned, the information officers, the specific officers, designated officers in each tech company. And there is also categorization for larger tech companies and smaller tech companies. So that classification has come in 2021, though the rules are under challenge, I must say. 2023, sir. Yeah, 3 is under challenge. So this 21 is also under challenge. 21 was also under challenge, sir. 21 also. 21 is on challenge. It's pending also in the Supreme Court. There was a transfer sought. So all of that is going on. So the difficulty is, there is a commercial interest to express and circulate this material, and there is a social and legal interest, and that's the interesting part. Even under the IT Act, all of this is being done by rules, regulations, guidelines, because legislature just can't keep. So if you see the provisions, they are broad-based, 67, 67A, etc. They're broad-based.
Interesting that there was a conversation about algorithms and how companies need to disclose their algorithms and how they're making those decisions. Other than the big tech companies, which can be brought to accountability to a certain extent, there are a lot of these small aggregators, small content creators, which are huge in this country. And there is no mechanism to really check when somebody's making content, uploading it, and it's going viral. It's only a reaction later that comes in. The point I'm trying to make is that the ecosystem has become so diverse and vast for any regulatory mechanism to catch up to it. And ma'am, the concept of elusiveness that you were talking about, I rather make an argument that has it become too elusive for the law to even catch up to it?
Well, I said that to begin with, but you see, I am questioning this wisdom of trying to regulate something, even on matters of ordinary censorship. In the UK, and the debates, say in the 60s and the 70s, after which they did away with pre-censorship altogether, was this: there is this view that the public itself pushes out stuff on its own in a healthy manner, and banning actually increases the interest. So my problem is with this obsession with regulation. A, it is ineffective. B, it may be counterproductive. And C, it can be regressive. The 2021 rules are so regressive. Pervasive government control over news media and creative media. So there is always, Sidharth mentioned legal interest, societal interest, and commercial interest. There is an overweening interest of the state to control information. So whether this obsession with regulation, certainly it has to be there, but to assume that first law, two criminal law, three preventive law is the answer to all social ills generally, and information proliferation specifically, is not a view that I personally subscribe to. So in that view of the matter, I have, where large and small aggregates do not figure in my scheme of understanding.
But ma'am, a follow-up question there. So then, when we deal with questions of obscenity there, and you talk about censorship, political censorship, or the interests of any government of the day to curb down on free speech, citing various provisions, we have seen certain instances that have happened recently where, say, certain sentiments of a particular person or a group were offended, and then they're given different sorts of meanings. In the midst of it, to have a definitive set of laws that define what's obscenity for you and what can be controlled, is that possible?
It's one of the most elusive concepts, and two, it is prone to the vagaries of the decision makers, the constables, and so on. So ultimately, what is it working out as? What you call obscene is proliferating, and it leads to the merest constable having the power to say yes or no to expression. So see, regulation is that regulation does. And I think that some aspects of expression, when subject to an elusive notion, are best left without regulating in the fashion in which pure expression. That's been my view for all time. Certainly child pornography, you check it. But when your regulation is not working, it's turning out, I'm repeating myself, turning out to be counterproductive. To come back to say now regulate, and I have serious issues about, seeking algorithms by the government from, it may work out. Justice Shakdher may, see, all of us are assuming that the government there is a neutral, efficient, honest agent, but it's being run by people. So control of expression, and I'm not talking about my expression or your expression, there's lots that I find offensive. But the question whether expression per se should be regulated is something we have to think about instead of assuming that that is the only way forward. I'm not saying that regulation is absolutely out, but our assumption that that is the only answer, and law and regulation, legal regimen is the only answer to many ills in society, is something we have to revisit. I mean, it needs another discussion to say what is and what should not be. But I don't assume that this is a panacea for all ills.
Sure. Luthra, you have a comment?
Yeah, so I'll just put a question to my very old friend Nitya. She's old. She's not old, I am, but she's an old friend.
Young friend of
Yes. Absolutely right. Very young friend of a very old man. So the point is this: does self-regulation work? And that's a real issue. We are now faced with three sets of interest. One is the freedom of speech and expression, and therefore the need for self-regulation. The second, regulation by the government, and I agree with Nitya that over-pervasive control is a problem in any regime, because that really is contrary to the principle of free speech. And the third issue is, which I think is going to trouble us a lot more now with AI coming in, let's say, with technology coming in, the ethics of technology, those who control technological tools. How are you going to make it, how are you going to reduce the element of bias in the use of technology? Because for my mind, whenever you start using technological tools, there are going to be fundamental biases which you may not be able to exclude them, but how do you reduce them? So that's a serious concern, but that balance will have to be found someday. And I think, young man, the next book.
I'd like to add a couple of observations here. Firstly, I think before we come to AI, what is it that's caused this whole demand for, as he said, obscenity sells? Every country, economic prosperity comes with its own negatives. I remember in childhood, we would have maybe 3 rooms in a house. We would all the kids would sleep together in one room, use one bathroom. And in those times, less obscenity, if you think like that, okay? But with economic prosperity, we have more comfortable homes, private rooms, smartphones, OTT accounts for all our children. The more they've had space, the more money they've had, the more comfort they've had, the more, even the adults, I think, with economic prosperity, that's what is making it sell, right? So, in this kind of a context, two questions then. Can you stop it? It can't be stopped. It's like water, it will just flow. Can you regulate it? The more you regulate, the more it becomes worse. So the way I look at it is, there are various ills of society which are being dealt with in a completely different manner. Let's look at that. For example, crackers. I remember 15 years ago when my kids were still in school, schools started a campaign, say no to crackers. And I must say, despite all the love that I had for crackers, my children would never agree. Even to today, they don't burn crackers. Same with piracy. Cinematograph films, on a Friday morning it would be released. It would be on the cable channel on Friday evening. But how was it changed? Every theatre had a nice warning in the beginning saying, this is what happens if you do, this is what you shouldn't do, don't camcord, don't do this. All this has happened because of promotional, persuasive campaigns. And I think that that's the way nudging should happen. That's the way, for example, you can think of anything as an ill or not an ill. We need to have positive campaigns and give the pros and cons to the youth. For example, in the Bandit Queen movie, I remember, Phulan Devi, in fact, I had the opportunity of meeting her at that time, when that movie was released. And that movie was challenged, Shekhar Kapoor's movie, in the Supreme Court. And there was so much violence in it and so much exposure in it. But the Supreme Court said, no, it's meant to convey a message about how this lady who was taken into captivity was dealt with violence. So therefore, I think everything that's exposure need not be obscene. And therefore, we need to have the right and the wrong correctly messaged in society. And that's where I think the media also plays a role. And doing it the right way in form of messaging would be an answer, in my view.
Before we take audience questions, Puja, obscenity sells and that concept is not new in the world of art, movies and cinema and entertainment. You'd know that better. But within the industry, especially with so many platforms for content, to be depicted or to be presented, is there an increasing sense of more creative freedom? Or perhaps you see a certain sense of phobia as to what may be palatable and what may be not. What's the largest sense and how it has changed over the years when it comes to putting content which was, say, obscene 10 years ago and is not?
As ma'am also mentioned, Bandit Queen, when Bandit Queen came out, there were protests about the depiction of frontal nudity, but it was to see why it made her the woman she did, because that I do understand, and it had to be seen in the creative context. But now, because of the creative freedom that OTT platforms have, a lot of things where we are exploring and questioning sexuality, where child abuse, marital rape, it has to be seen in that context. So, but sometimes as also to titillate, as a filmmaker himself said, sometimes that's just added for the, sorry to use the word, for the heck of it. Just there, when it's not even required. But the larger sense that I do feel is, I think the writers, the creators are well aware about how they are depicting what they are depicting. So it has to be seen that, because everything vulgar is not obscene. It also depends about how you're consuming it. You and me and the rest of us sitting here will say, yes, this happens, move on. And the actor who's also doing it is also, saying yes for a reason to basically get a message sent across. But a whole lot of times things are very, very extremely uncomfortable, and you do question why. That's, I think, where censorship does come in, and they see that, as I also mentioned, that this will not be acceptable to somebody, say, in Ranchi, who's seeing it saying, ye theek nahi hai. And like a movie called Devi was banned because it depicted the goddess in a certain way. But I do remember one of my first stories for NDTV was the erotica in Khajuraho. You know, that was a story, and there was a discussion on it. It, I think, also depends on the mindset, because in the 1990s, Puja Bhatt was on the cover of every magazine where her body was painted. And honestly, I was 20 then. It didn't look bad at all. But now you see a Ranveer Singh and a Urfi Javed, and sometimes I just say, like, what is the need? But then, uska creative freedom hai, uska artistic expression hai, so be it. I'm like, I just feel what the repercussions will be, because when you see the comments, no one can control those comments. And as you said, AI, Twitter has AI who takes your complaints. So nothing comes out of it. So, but I do see there's a lot of awareness amongst filmmakers, artists, and writers. Everything is not done for titillation. It needs to be seen in the correct context. But
One question. Should an AI-generated porn movie have copyright?
oh my, ma'am, let's not. Let's not even get there, ma'am. Let's
Is
not
that a
even
trick
get
question?
See, the problem is they've yet not recognized AI as the creator or inventor. A lot of countries don't recognize that, and therefore, either the law is always post facto. It needs to evolve. But I think there is one thing that I want to sort of end with is we are conflating perhaps two different areas. One is that definitely there should be freedom of speech and expression, and that's where creative artists, authors come in. So just because there is some sexual content, it has to be contextualized and seen how it is portrayed. The other is, as I gave an example, child porn, or these videos of women being raped being uploaded. They definitely need to be tamped down. So, the test is, one of the American judges put it very well. He said, when it is dirt for dirt or dirt for money, I would tamp it down. So, I think that's what, but as I said, and I agree with Nitya also, you can't throw the baby out with the bathwater. In trying to regulate, please be sure that we may hate the social media, but this is the power of internet. You take away internet today, a lot of people who have opportunities of, will be taken away. I mean, everyone can't get a, article published in print media. So you need to balance that and keep that in mind when you regulate. And but yes, certainly there is a certain area, as I said, which needs to be tamped down, and everyone would agree. But that's what we have to figure out.
Sure. On that note, I think we can take some audience questions as well.
One thing which we have always overlooked, and we have diluted to an extent that we have taken over the whole regime of the freedom of expression to a level where we have stopped bothering about others, the person sitting next to me. So, what is the view of the panel on this whole dilution of the law of defamation? I know Nitya will balk at it because she is anti-regulation. But we have really, I can understand that, as we can say that any expression which is blocked by the state or a regulator could be violative of free speech. But at the same time, when it's between two parties, and obviously there's an element of exposure, element of defamation, element of names, element of identification with some people, is it not something where we stop drawing a line, and that is one of the indicators of why we have reached this stage? And the second aspect is the platform, the social platforms, and this whole. And in that context, if I am going to use a marketplace to place a product which is per se violative of any other law, for example, it's not complying with, or it's a product liability, the product liability still sits with the person who has made that product. But at the same time, because there is a marketplace, there's a protection of safe harbor. These are two issues which we have never how do you balance out the exposure of the person who has manufactured that or created that content and somebody who's placing it on the platform?
So two things. To answer the second question first, the manufacturer or the seller of the product is liable for any act which is in breach of the law. All selling platforms make that restriction very clear that you can't do anything in breach of the law. The law is applicable because these platforms operate across the world. Having said that, 79 has a safe harbor provision provided you fall within the categories that you are not. So there are two kinds of selling platforms. There may be those who are the distinction between active and passive are not really made. But there are times when, let's say, you're actually selling the product yourself. So you are not just a intermediary, but you cease to be an intermediary because you are participant in the process. That's the area when things change and liability will come. That was the one part. On defamation, I'll leave it to Nitya. I have my views. There's no right to reputation any longer.
No, but what was your question? You see, the point is, as I started, it is not as though there are not issues. The question is whether criminal law is the answer. So whether it's between the state and the citizen or between two citizens, the question is how life and liberty, why must everything be criminalized? That's the question I have. I'm not saying reputation is not relevant, or that's one thing. The other thing is also, you see, these are negotiated spaces, because I've had some discussion with media professionals, media teachers and so on. It's not as though just by looking at a scene, a child will immediately go and commit a crime. So these, media reflects society, creative media reflects society, and society may reflect creative media in various ways. These are negotiated spaces. And what do you do? Today we live at a time when just for expressing a political view or taking an argument in court, if it is publicized, you face profanity. So it's not only as though obscene images give rise to a certain form of expression. So social issue, somebody asked about women. I'm sorry, it seemed to be digressing, but I hope it all adds up. The fact is, today we are living in times where profanity has become acceptable discourse on TV channels. Anchors use it. It's become a form of political debate. In this wider scheme, we are focusing on a degree of images, a certain expression, and saying, now how do you deal with this? You see, if you look at even expressions or letters between political rivals, say in the 50s and 40s, the extent of civility of discourse, there is no civility of discourse anymore. So just to check on one aspect of the matter and say, this must be subject to policing, seems not to recognize that there is a social degradation of various kinds in discourse that is happening. So just to look at law and criminal law, whether it's in the context of reputation or in the context of obscenity, only needs a rethink. That's what I'm saying.
Obviously, any implication on a claim for damages premised on defamatory content is virtually non-existent.
Yeah, well,
See, at the moment you are in good space because the judgment in Dr. Subramaniam Swamy case repaired the challenge to section 499 and 500. So the law stays. But I mean, it's above my pay grade. But I agree with Nitya. It should not be criminalized. You can always take the other person to court in a tort action. And the court should now feel free in these cases to impose heavy damages and give away, because if there is injury to reputation, and that will... In a virtually non-existent tort.
Sir.
No, see, it will develop if judges start... that's an area which is, yes, you're right, it's sort of not developed to the extent, and we are always very nervous about awarding. But I don't think going the criminal way is the right...
So I'll just add two things. There is a fundamental problem at how we look at society. Look at the last 5 decades. We brought criminal law to every aspect of our life, and I think that's seriously a serious problem. From birth to death, the criminal law touches us at every point. That has to stop. Having said that, I was in effect, though I was appearing for one of the parties, I ended up assisting the court in the defamation of Subramaniam Swamy, which it was upheld. So, but speaking for myself, I believe that is not the way. We really do need to buffer up the remedies. There is, when I said there's no right of reputation, the fact is there is no effective remedy for malicious prosecution. No effective remedy. There is no effective remedy against being defamed. The remedy of defamation, even criminal defamation, is meant only for a certain class, which used to be in the round building in India Gate. Now it is a triangular building, I'm told. But the point is this, how to, and in 2012, the Constitution bench said, look, if you are accused or if there's civil action, you can seek a gag order. The honorable judges are there, and therefore it would not be appropriate to ask this question. But yet, I want to ask, in how many cases do you get you get a gag order? I've seen it yesterday, and I can say this, I was... No, sir, ये नहीं, मैं आपको नहीं पूछूंगा. I'll go outside your jurisdiction. Let me do this. I'll go outside your
I'm only scared of one thing, that Mr. Atul Sharma will get an invoice from both of them here.
And you actually seriously believe when he says,
I think we can have a couple of more questions if there are more questions.
Good evening, all the panelists. So, as Prathiba ma'am pointed out, that students are susceptible to influence and learning in the school environment. Do you believe that it's essential to incorporate sex education or provide students with the educations since they represent the society? Ma'am, please.
I would say triple yes. Absolutely. I think the Indian society has, at least from the way we were brought up, having, a block against talking about sex and talking about menstruals or talking about periods in school. But yes, it had changed over the last 10, 15 years. And I think sex education is absolutely essential in schooling. And because nowadays the social media exposure, the age is reducing for children to be exposed, and I think that's absolutely essential. That's my own view, personally.
I believe we can carry on this discussion for hours, but we've run out of time. It has been fantastic to discuss this topic with all of you. And Saurabh, I think you have a lot of material for the successive books. Ladies and gentlemen, a huge round of applause for the esteemed panel and for them to take out time for us.
Wow, what an amazing panel discussion it was. We really did not want it to end, but as Anusha said, it cannot go on for hours. Thank you so much for that panel discussion. I think now it's time to invite Mr. Bindal for his concluding remarks.
Thank you, everyone. Thank you, the dignitaries on the dais. Thank you, Honorable Justice Shakdher, Honorable Justice Prathiba Singh, Sidharth, Luthra sir, Nitya ma'am, Anusha ma'am, Puja ma'am. Thank you for being part of this panel. It was such an elaborate and exhaustive discussion. I don't want to stand between the high tea because the audience have heard about what the book is. The book talks about a subject which has not been dealt in India by any of the authors. I would only like to, read one of, I'll read a paragraph from the foreword because it is Justice B.R. Gawai has written the foreword for the book. So I would read one of the paragraphs for the foreword, and then I would like to conclude with the acknowledgements in the book. Justice Gawai writes that the term obscenity has not been defined in a straight-jacketed manner in any legislation. Its interpretation depends upon the morality of a society, which keeps on evolving from time to time. What was obscene in the past may not classify as obscene in the present, and vice versa. This is because of changing perceptions in society of what constitutes as obscene. While there are several legislations on this issue, jurisprudence in India has seen a marked shift away from the English standard to judge a potential case of obscenity, the Hicklin test, to the contemporary community standard test, about which we have heard from Justice Shakdher. The book serves as an invaluable resource for legal scholars, practitioners, policymakers, artists, and anyone with keen interest in this dynamic interplay between freedom of expression, cultural values, and the law. I commend Saurabh for his comprehensive research, thought-provoking, that's a self-praise,
But I commend Saurabh for his comprehensive research, thought-provoking insights, and balanced analysis. So I would recommend everyone to get a copy of this book today, because the signatures I'll do on that book will be free today, and after that, as a lawyer, I'll be charging for those signatures. I'll read the acknowledgement. It's because no one reads the acknowledgement for the book, and it is very close to me. This book is a gift to all those who have trusted me through thick and thin. Their contribution to my life has been immense. I am indebted for their everlasting trust in me. They have meant the world to me. I would like to place on record my gratitude towards my parents. My father-in-law is also here. I recently got married, so just when I was doing this book, Mr. Malik used to call me and he used to tell me that you have a lot of patience. And I want to tell him that I recently got married, so he knows now that where the patience is coming from. No, but I have a beautiful wife sitting there, so I would like to place on record my gratitude towards my parents. I have imbibed all the patience in me through them. My father has taught me perseverance, and my mother has given me the will to stand. My sisters deserve a special mention in this book. They have taught me to be upright in my demeanor and have always loved me beyond boundaries. My brother-in-laws have also been pillars in my life. They have always treated me like their younger brother and have always made themselves available for me in one shout. The work will be incomplete if I fail to mention my nieces and nephews. They have taught me to be humble and at the same time urge for more in life. Their love for me has been immense, source of inspiration. While I was preparing the manuscript of this book, I also met my wife. This book becomes more special for me as it is her presence in my life which pushes me to do things. She has brought love to me, and love is all you need. I'll do injustice if I fail to mention my alma mater. Some of you might be knowing that I've done my engineering and then I've done law from IIT Kharagpur. So it would be, if it would not have been, the love my law school has showered on me all throughout my career, this feat would not have been possible. I would specifically like to mention Dr. Uday Shankar for his contribution in my life. He, in truest sense, has been a friend, philosopher, and guide. He brought pen and paper to me. He is one of the associate professors in my law school. I would also like to place on record special thanks to the batchmates from my law school who have always pushed me to do better. Some of my batchmates are sitting there. The list of people who have made significant contribution to my life is long, and that is why Atul sir is there, and you can find people from L&T and different companies here. This list of people is long, and I would not be able to mention everyone here. However, each one deserves a special place in my heart, and I owe gratitude to them. I would also like to mention Mr. Sumit Malik, Director of Eastern Book Company, who has been kind enough to accept this manuscript for publication. He has always held my hand through thick and thin. My professional life would be incomplete if I failed to acknowledge him. Mr. Surender Malik has, like a father, blessed this script with his critical review. His blessings on the book mean a lot to me. His critical review made me revise the script several times. Last but not the least, I would also like to, thank the Almighty, and I should also, thank the Eastern Book Company team, specifically Bhumika. I was here for a book launch, and there, Bhumika caught hold of me. She said, "This is your 8th book. You have to make it special." So, this is all Bhumika's hard work. Prachi is also there, the DTP team, the citation team. Thanks a lot for having me here. Thank you.
Thank you so much, Saurabh, for those kind words and appreciation. I would now like to request my colleague and friend, Ms. Bhumika Indolia, to deliver the vote of thanks.
I will not take much of your time. I will wrap this up very quickly. Just want to say that behind every successful event, there are countless hands that work tirelessly, hearts that beat with dedication, and minds with creativity. As we come close of this remarkable gathering, I stand before you all on behalf of EBC to express my gratitude to all those who have made this event possible. We wish to offer our heartfelt gratitude to Justice Rajiv Shakdher, Justice Prathiba Singh, Mr. Sidharth Luthra, Ms. Nitya Ramakrishnan, Ms. Puja Talwar for taking out time from their busy schedules to be with us this evening. Your thoughts have enriched us and have given us much to ponder and reflect upon. Ms. Anusha, Soni for moderating an engaging and meaningful panel discussion. Your ability to steer the conversation was truly remarkable. We are grateful to Mr. Saurabh Bindal for writing this insightful book that will enrich legal professionals, artists, and laymen alike. The EBC team, including the editors, the copy editors, proofreaders, typesetters, for putting this work together. Your attention to detail, commitment to excellence, and willingness to go above and beyond to ensure the book's success is commendable. Our production team and Thompson Press for bringing the book to life. Your dedication to delivering a high-quality product is evident on every page. The sales and marketing teams who will truly take this work to the readers. We appreciate your commitment to reaching a wider audience. The organizing team, Ms. Prachi Bhardwaj, Ms. Kriti Kumar, Ms. Apurva Goyal, Ms. Riddhi Khurana, Ms. Diksha Dabas, Ms. Parveen Bano, Mr. Amit Tiwari, Mr. Sajan Agarwal, Mr. Sanjay Suman, who alongside me have worked tirelessly behind the scenes to ensure the success of this event. The Lalit team for helping us hosting this event, and all the media houses for covering the event. And last but not the least, I would like to thank each and every one of you for attending this event. Your support and participation has made this event truly memorable, and we hope that you have found it informative and enjoyable. With this, I would like to declare the end of this event. I request all of you to proceed for high tea.